Welcome to Rationally Based, a podcast about law and politics on the edge. Grace and Kathryn, what are we talking about today?
Well, today we're talking about the lawsuit filed by Minnesota against the federal government. Does it have any merit? Trump's options if things continue to deteriorate, including the Insurrection Act. And what is the role of the courts in all this, including with respect to administrative arrest warrants? And if time, we'll talk about the storming of City's Church, the FACE Act, and the First Amendment.
That's my favorite topic for the day.
Let's dive in.
I'm your host, Ilan Wurman, a law professor at the University of Minnesota Law School. I'm joined here with the two wonderful ladies, Grace and Kathryn. You want to introduce yourself?
Yeah, sure. I'm Kathryn. I host the American Experiment podcast with Grace. I'm also the development director at Center of the American Experiment. And I think we're just here to bring the everyman's view to this podcast. Wouldn't you say, Grace?
That's our goal, yes. I am director of marketing here at American Experiment, which means I have no legal background. And I'm very excited to have Ilan here to help us through the legal issues of today.
Well, I'm very excited that the Center for American Experiment is producing this podcast for us. It is a wonderful think tank here in Minnesota. I'm based here in Minnesota at the law school, so I think this will be a fun collaboration. So why don't we dive in?
Yeah, let's start at the top. So obviously, ICE has been in Minneapolis over the last few weeks carrying out immigration enforcement activities. They've been clashing repeatedly with protesters and even local law enforcement from time to time. I mean, you've seen like the chief of the Minneapolis police repeatedly asking ICE to leave, the mayor's saying things, the governor's saying things, protesters are getting more aggressive. We've had 2 civilian deaths at this point. Luckily, we are seeing some signs of hope. If you've been watching the news, there was this phone call that just happened between Governor Walz and President Trump. Both sides are saying it was very positive. Both sides are basically claiming victory. It doesn't make sense, but okay. It seems like a good outcome.
Yeah.
That this issue is not going away, though, even if there's like some hope on the horizon. Like, this is not going away anytime soon. I mean, right now, like, there's a lawsuit in play arguing that what ICE has been doing here in Minneapolis is completely unconstitutional because it violates the 10th Amendment. So first things first, Ilan, is what ICE has been doing in the Twin Cities over the last few weeks legal? Does this lawsuit have any chance of succeeding? And because I can't get my head around the fact because doesn't the federal government have the final say in immigration enforcement?
All great questions. So the lawsuit strikes me as something out of the Old South, this argument that the federal government doesn't have the right to enforce the laws. I think Keith Ellison's lawsuit is dead on arrival. So I think we have to keep a few things in mind here. The first being that federal law is supreme over state law. Now, to be clear, federal law is supreme over state law within the domain of the national government's power. So everybody agrees, okay, well, maybe not everybody. There are some dissenting voices about this, but the conventional wisdom, and in this case, I think the conventional wisdom is correct. Usually I think conventional wisdoms are at least often wrong, but this is correct, that the national government is limited to its enumerated spheres. There's an enumeration of power in Article 1, Section 8, and the national government is limited to its particular sphere. And the states have sort of this residuum of power. But within the national government's sphere, within its proper and legitimate powers, it is supreme. Article 6 of the Constitution has something called the Supremacy Clause that specifically says federal law is supreme over contrary state law. So what this lawsuit seems to be suggesting, it seems to be invoking like the famous tariff of abominations and the nullification crisis in South Carolina in the 1820s and 1830s, where South Carolina said, we think the tariff's unconstitutional. It's certainly bad as a policy matter for Southern interests, and it purported to nullify federal law. It purported to say the federal law does not have effect in South Carolina, and Andrew Jackson, a Southerner, and Congress enacted the Force Act, authorizing President Jackson to send in the army to make sure that federal law is enforced. And so this is what's happening here in a sense. So long as immigration is within the scope of the national government's power, the president has the right to ensure that that law is faithfully executed. Now, is immigration, a national power? Everyone says yes. Everyone seems to agree that it is, though it's actually kind of funny. Like, where does it come from in the Constitution? I mentioned Article 1, Section 8. There's no immigration clause in there. There's like a naturalization clause, which seems to give Congress the power to make citizens out of foreigners, but not necessarily to control who comes, which foreigners come into the country. So maybe it's left to the states. But there is another clause, the infamous Atlantic slave trade clause, which says Congress can't prohibit the migration or importation of certain persons until 1808, implying Congress has that power. Where does that power come from? Well, it's debated. Academics debate it. Chris Green at Ohio State has this theory about the foreign commerce power. Robert Nadelson has this theory about the law of nations. Congress has the power to define offenses against the law of nations. And it was an offense against the law of nations to come into a country illegally. The Supreme Court eventually said, oh, it's an inherent attribute of national sovereignty to control immigration. Anyway, it's kind of a quirky, interesting topic that we don't have to get into. But I think the point here is nobody really disputes that immigration is a valid national power. And if that's true, then national law in this domain is supreme over contrary state law. And the federal government and the president has the duty to ensure faithful execution, including in Minnesota.
I do have one additional question for you, because to me it seems like in Minnesota, our state does have laws pertaining to immigration. Minneapolis, for example, and St. Paul, they're both sanctuary cities where they have laws that don't allow officers to work with ICE in certain ways. Isn't that in and of itself trying to regulate immigration and outside of the bounds of what a state can do?
So another great question. There's a doctrine involved here called commandeering. The question is, can the federal government co-opt state law enforcement officials into the operation of the federal government to help enforce federal law? And there's some interesting inconsistency here, potentially. I like to tell my constitutional law students when I teach this subject that whatever your view on this question, whether the national government can co-opt, coerce, commandeer state officers, that you should be consistent about this view whenever the other side is in power. So in the 1990s, this issue emerged. If the Brady handgun bill, I think it was named after the Secret Service agent that died protecting Ronald Reagan. It created the system of national background checks. And temporarily, as the national government was setting this up, it co-opted state officers to help run these background checks. So basically, their county officials, local officials had to enforce the background check. Well, I think it was Arizona and Montana. Naturally, there were some sheriffs who were like, we don't want to do background checks on the guns. And so they said that this was an unlawful exercise of power, that Congress doesn't have the power to commandeer the states, and in a case, or commandeer state officials. And in a case called Prince against the United States, the conservative justices at the time, including in an opinion written by Justice Scalia, said, that's right, you don't have the power to actually force state officers to enforce the law. Well, now the federal law, now the shoe's on the other foot a bit. I'm sure the conservatives would love the ability to co-opt and commandeer state officers to help enforce the law. So look, now sanctuary policies are a bit different, right? I mean, so the question I think is, when an ICE officer calls a jail and says, okay, hold this individual who's in your jail. So not only, by the way, is this person, unlawfully present in the United States, but they've committed crimes, right?
Additional crimes. Because they already committed the original crime, and now there's more crimes, often, and they're in jail.
So these are like the kinds of individuals that even, Barack Obama was like, yeah, we want to deport these individuals. So if they get a call and say, can you hold this person for a little while longer so that we could come and enforce the federal laws, is that commandeering? I mean, it's kind of an interesting question. I mean, it's kind of saying, can you just hold them a little bit longer so that we can come enforce the law? We don't want you to enforce the law. We will enforce federal law. So on the other hand, if you hold somebody longer than you otherwise would, are you sort of enforcing federal law temporarily for a few minutes? Like it's a super interesting question. But then, there is something else that bothers me about it, which is, if you get a call or that somebody is wanted by the government and then you release them, kind of help them escape, so to speak. If you were a private person, wouldn't you be charged as an accomplice,
right,
or an accessory after the fact to some sort of crime? I mean, I don't know. I mean, you're not obligated to, criminal law isn't my expertise here. You're not obligated to catch criminals or something, or catch fugitives. You can't help them after the fact. But this is actually a fine line. It's kind of blurry what they are actually doing. But in any event, you can't commandeer state officers, but it's certainly the case that state officers also can't obstruct obstruct and interfere with federal law enforcement. And there is some argument that that's what's happening in the sanctuary policies.
Well,
Yeah.
it's interesting to see how this has played out in different states. Like some states have cooperated much more. They've been willing to grant the ICE detainers and hold on to criminals for longer so that ICE can come in and arrest them. But states like Minnesota, who are refusing to participate, we've seen this mass chaos. And that just hasn't happened in places like Texas or even Michigan, where they're carrying out the same sort of immigration enforcement, but with far less chaos because they're working together.
Yeah, there are, I mean, like you said, it's red states, it's blue states who have chosen to work with ICE and not fight the federal government on this illegal immigration issue. And you're not seeing protesters, you're not seeing people literally dying in the streets because these protests are getting so violent because they're interfering with federal agents' work. And that's what boggles my mind is I think that there's this real mentality in Minnesota that comes from liberals that, this is the compassionate thing to do. We love our neighbors. We want to support them. This is, so get out, feds. I think that not enforcing our immigration laws and our borders is the most compassionate thing to do. And yet the state that has chosen to take that route is the state that's having all of this chaos, all of this violence, all of this trauma, people keep saying. This very traumatic event that's happening.
Yeah, it's interesting because as a historical matter, the people who were distrustful of national government power, of federal government power, actually wanted state officers to enforce federal law, to assist. So the anti-federalists distrusted what they would often call a swarm of harpies, which would be the federal officers. What's
a harpy? A federal officer?
I guess you could call that. And that's what the anti-federalists worried about.
Is that like a slur, a harpy? Can I use that in my day-to-day?
I do think they had much more intelligent insults back then.
Okay.
Isn't that like a Greek myth, harpies? Am I crazy?
I probably think there's a mythological character. But nevertheless,
Producer Isaac, fact check us.
That if you read the things that people said about like John Adams and like the political attacks, they were much more clever than we are today. But so swarm of harpies, swarm of harpies, and the Declaration of Independence actually accused King George of sending a swarm of officers to eat the substance of the people. So this is definitely was sort of this concern that they had. But so there's this article in the Yale Law Journal by a friend of mine, Judd Campbell, called "Commandeering and Constitutional Change," where he argues that the case that discussed the commandeering issue, this Prince case, kind of got the political valence, the ideology of the founding generation exactly backwards. It was the anti-federalists. It was the people distrustful of central government power who actually wanted state officers to help enforce federal law because the federal government, they might send in officers from out of state.
Sure.
Kind of like what we're seeing in Minnesota. And so if state officers were helping to enforce the law, they would be closer to the people. A lot of state law enforcement at the time were also elected by the people. Like sheriffs even today are still elected by the people. Sure. They're closer to the community.
So if it's going to happen either way, let's do it on our terms, basically.
Exactly. But it has to happen.
Right.
Otherwise, the national government has a right to step in and supply their own officers. And so there is something kind of backward about the whole sanctuary city policies, right? If you want to keep the federal government at bay, then you want state officers to sort of interpose and intercede, in between, be a shield between the federal government and the people. But that requires them to conscientiously assist in the execution of federal law, not to obstruct the execution of federal law. So I thought we might talk about this. So I have this passage from Judd Campbell's paper, again, Commandeering and Constitutional Change, which I just love it. So I'm going to read it. One of the few things I printed out here. So he says, the anti-federalists were actually among the strongest supporters of commandeering of state officers, both before and after ratification. State officers were drawn from local communities and were sympathetic to local needs. Whereas federal employees, like their British predecessors, would be unforgiving, unaccountable, and perhaps even tyrannical. Proponents of state power genuinely, though at times hyperbolically, feared that a burgeoning federal bureaucracy would quickly become and here we go, swarm of harpies. Yes. I love that. I do love that. Swarm of harpy. You're a harpy. I'm gonna start a swarm of harpies who, under the denomination of revenue officers, so-called tax officials, would range through the country, prying into every man's house and affairs, and like a Macedonian phalanx, bear down all before them. And so that's a quote from Rep. Josiah
What a time to be alive.
Wow.
Oh my gosh, great
Can you
language.
imagine a member of Congress speaking like this so beautifully and eloquently and yet cutting and insulting?
Wonderful.
Anyway, so the point is, I think this phone call between Walz and the president is a good development. We want federal state cooperation. We want federal-state cooperation. We don't want the federal government being solely responsible for the execution of all federal laws. If it came to that, then we would need a huge, massive federal bureaucracy, a swarm of these officers who may be from out of state, who wouldn't be attuned to the interests of the people. And so I think these sanctuary city policies are a bit of a miscalculation. I think the anti-federalists would say, actually, no, we will help and moderate and temper the enforcement of federal law. So hopefully this phone call, I don't know, what do you think? Is it legit? Are there going to be changes? Is there going to be cooperation? I mean,
well, it's so interesting to me that was kind of the attitude of the day that, okay, federal law is obviously going to be imposed. Like, there's no ifs about it. But we're here today in 2026, and we've seen the kind of chaos that has been caused in Minnesota by George Floyd and other things since 2020. And we're used to lawlessness. We have this kind of like, we're okay with it, I feel like. And it is a question. Are we going to enforce federal law? Not, okay, it's going to happen. What's the best way to do it?
Well, is it a question every 4 years? It's a new question.
Yeah.
Right? I just feel like in D.C. or in Minnesota or any state, whether you believe in federalism depends on whether your person is in the White House and whether your people are in Congress. So, so the abolitionists, for example, believed in federalism until when the national government was in the control of the slave power. And then when they got into power, of course, they wanted to abolish it. And they did it through a constitutional amendment, which is the right way to do it. But the point is, as a general matter, absent fundamental moral issues like, slavery, these fundamental issues of justice, you have to accept the possibility that sometimes when the other side's in charge, states are going to do their own things or the federal government's going to do their own thing. Whatever your theory here is of the distribution of national and state power, it should just be consistent. It shouldn't be, I believe in national power when I'm in charge of the national government, and I don't believe in national power when the other side, So who knows what's going to happen here?
It's the whole immigration debate, though, has kind of changed from not that long ago when we had, Amy Klobuchar was saying we need a border wall back in 2006. That's crazy when you think about it, because now conservatives are all being called extremists because we want to just abide by federal law and put a cap on immigration, deport illegal immigrants. How is that extreme? Not that long ago, people on the left, that's what they wanted, because they didn't want, low-wage workers coming in and driving down wages for the middle class. That was a big Bernie Sanders thing. Now, that's like what Trump and everyone on the right is saying. It's been this complete ideological shift, which is interesting. And I don't know how the Democrats ended up at being just the open borders radicals that used to be the libertarians, really. The Koch brothers are the ones who were like, open borders, let's do it. We don't need it. Now, that's just the people on the left. That's Walz. That's Amy Klobuchar. Crazy how in that short amount of time, those things can just completely change.
I wonder how these cities and counties in Minnesota that have implemented sanctuary policies are going to, because I think they will walk them back and start cooperating quietly with the federal government on this issue. And I wonder how they do that without making it seem like a loser's retreat. I mean, there are 20 counties and 2 cities in Minnesota that were called out by DHS, Department of Homeland Security, for obstructing these federal immigration laws. Obviously, you've got Ramsey, you've got Hennepin counties, but it's Minneapolis, St. Paul, and there's quite a few counties actually they identified, even in greater Minnesota. And so I think it'll be, if this phone call is legitimate and good things come out of it, I will be interested to see how the politics play out of justifying to their very angry activist base why they are no longer calling on them to go fight ICE in the streets.
I'm so ready to move past this in Minnesota, but I'm also so done with people thinking that they can just not follow the law. They can do whatever they want. They can have these underground networks of people on Signal chats who are coordinating their own militia, literally, within the streets of Minneapolis, and that's fine.
Yeah.
So on one hand, happy, want to see resolution, of course, and don't want to see any more violence. On the other hand, it's like, well, I do not want the lawless people to win.
Right. This sets a dangerous precedent if there are no consequences for these, basically militia groups that have formed on the streets. Because it gets past the point of protest. It gets to the point of, you almost want to use the word insurrection. And I do want to talk about the Insurrection Act, because I think that if we let this moment go by and we're happy that all of the violence has stopped and all the chaos has ended, and we don't litigate this issue of whether he could have called in the Insurrection Act, President Trump could have invoked it. If we don't cover that now, I fear that something like this could happen again in the next couple of years.
So, of course, hopefully the point of state-federal cooperation is you don't have to invoke the Insurrection Act, and the president has shown some good sense in using it as a last resort. But and he hasn't even invoked it. But the question is, could he invoke it given the situation that we see in Minnesota? And certainly on the face of the statute, he probably could, because the statute, although it's called the Insurrection Act, it really wasn't called the Insurrection Act until 1807. It deals with much more. It was an amendment to what was originally called the Militia Act of 1792. And I know you mentioned the militias. Who has control of the militias? Yes, we seem to have unorganized, extra-legal militias, perhaps, roaming the streets of Minneapolis. But the Constitution assigns to Congress, in Article in Section 8, the power to provide for calling forth the militia to do three things: to suppress or to repel invasion, to suppress insurrection, and to execute the laws of the Union. And so the Militia Act basically provides, here are the conditions that in which we authorize the president to use the militia or the armed forces. And who's the militia, by the way? It's actually just the armed body of the people. I mean, today we have an organized militia, which is the National Guard, and an unorganized militia. But basically to use the armed body of the people, the militia or the armed forces, to do a few things, including to see that the laws are faithfully executed. So the statute, I want to get it right. Do we have it in front of us here?
Yes.
It says, whenever the president considers that unlawful obstructions, combinations, or assemblages, or rebellion against the authority of the United States. So this is important. It's not just about insurrection. It's not just about rebellion, right? It's any obstruction, any combination, any assemblage that makes it impracticable to enforce the laws of the United States in any state by the ordinary course of judicial proceedings. He may call into federal service such of the militia of any state and use such of the armed forces as he considers necessary to enforce those laws and to suppress the rebellion.
That feels pretty cut and dry to me.
Yeah, so I mean, we probably should, the clips coming out of Minnesota are pretty crazy.
Yeah. So the question is this, right? The question is, are the people of Minnesota making it impracticable? It's a new word on me. Impracticable to enforce the laws? That's kind of the question, right?
By the ordinary course of judicial proceedings. So there's a number of ways that this could happen, right? I mean, if the local officials aren't actually stepping in to arrest people and to police the situation, then it never gets to a judicial proceeding. Another possibility is if you have jury nullification, which would be super interesting. Is that jury nullification, does that make it, or judicial nullification, does that mean the ordinary course of judicial proceedings are making it impracticable? So it depends, where are the local police, where are the state officers, and are the obstructions really such that the laws are unable to be executed? Now, I should say that although statutorily this is quite a broad statute, and the president would be on good statutory authority to invoke it, it is understood to be sort of in tension with this, I'm going to say small c constitutional principle that we shouldn't use the military to enforce federal law. This is not in the Constitution.
What is the difference between large c and small c? How can it be a small c if it's not in the Constitution?
Okay, this is
just quick diversion.
This is a broader discussion about constitutionalism and whether our constitutional principles only come from the written text of the Constitution, or there's these other customary prescriptive constitutional practices.
The breathing constitution or whatever?
Okay, all right. I'm getting trolled now. That's
honestly, what the left calls it, isn't it?
Okay. If you ask me, the more based version, if I may use the term, of this view is, Adrian Vermeule, for example, at Harvard argues that there actually are these small c constitutional principles that judges can enforce, this common good constitutionalism. Look, we should have Adrian on the show, actually. Maybe he could be our first guest, Adrian, if you're listening. So we could talk about this question about small c constitutional principles and whether there are these principles that are outside the text that emanate from other principles, natural law, custom, the practice of nations that are independently enforceable. This is a super interesting theoretical topic. But before, all I want
not
to
an
say,
easy answer, I'm hearing.
I get it. I get it.
Not an easy answer. I have been accused of being a living constitutionalist before. I feel like what you're accusing me of is being a conservative living constitutionalist, but I'm not. I'm a textualist. I'm an originalist. But it's more complicated. I do believe, as a cultural matter, we have these constitutional ideals or principles, even if they're not in the written text. That doesn't necessarily mean that they're judicially enforceable. Okay, so that's an important difference. But the Posse Comitatus Act is a law that says we can't, generally speaking, use the federal army the national army to enforce the laws. I feel like this is a a statute that has a constitutional-like aura to it, it doesn't mean that a violation, or if we repealed the Posse Comitatus Act, that would be problematic. But my point is there's this cultural, customary, prescriptive constitutional view, understanding that the military shouldn't be used for domestic law enforcement. So it should be rare. Of course, the militia clause says you can actually use the militia for domestic law enforcement.
Right.
But the point is it should be narrowly construed. It should be a last resort. And I think it's quite good that the president has shown good judgment until now, holding his fire on the Insurrection Act. But it is available to him, I think, if the situation further deteriorates. In fact, don't we have a clip of
let's go. Let's look at one of the clips we have here is what we thought maybe might show a little bit of the
chaos, the Minneapolis chaos.
Making it impracticable to enforce laws. Let's see. Is this impractical?
Impracticable.
Impracticable. Isaac, go ahead. So, for our listening audience, we have a federal vehicle trying to get down the street, and a mass of protesters holding signs, an upside-down American flag, stopping the vehicle.
And there is no local police in sight. Though, by the way, when we say federal agents, I mean, that looks like a military vehicle, which is kind of, I mean, were those local troopers? I think I just saw local officers just standing there.
Yeah.
So that's super interesting.
Yep, there you go.
So anyway, the militarization of the police forces is another kind of interesting topic for the future. But yeah, I mean, that looks pretty obstructive. It looked like an unlawful assembly to me. It looked like an unlawful obstruction.
Yeah.
And if local officials are not going to police that to allow the execution of federal law, then it does seem like it would meet the statutory terms of impracticable, to enforce the laws by the ordinary course of judicial proceedings. So you're never going to get a judicial proceeding if the local officials don't make arrests and there isn't
Right.
process. So, yeah, but again, it should be a last resort. So hopefully we'll see some good developments here with Walz and Trump.
So if it is supposed to be a last resort, what else could President Trump have done to kind of quell the chaos that was happening in the Twin Cities over the last few weeks? I know you've talked before, I think it's maybe part of your upcoming book, but this idea of like the president's protective power. You are so welcome. What is that? Is that something he could have used here?
Thank you for giving me the opportunity to plug my forthcoming book called The Constitution of 1789, A New Introduction. It's forthcoming with Cambridge University Press on July 4, 1776. The semi-quincentennial, what are you calling it? The 250th anniversary? America 250?
Yeah.
Okay, if you prefer Latin, semi-quincentennial. If you prefer less Latin, quarter millennial.
I can't even say impracticable. Okay. I can't say quintentennial or whatever you're saying.
The semi-quincentennial. Well, okay, so the book is coming out then. And it has this chapter on inherent executive power. And I'm actually generally a skeptic of inherent executive power. I really believe that the Constitution's text really accounts for all of the necessary powers that the national government has to exercise: Congress, the president, the courts. But there's a super interesting case that has been interpreted to create this inherent protective power in the presidency, that the president has this inherent power to protect federal officials in the execution of their duties, even without statutory authority. So this is a crazy case. It comes from a crazy case called In re Nagel, where a former justice of the California Supreme Court actually tried to assassinate a justice of the U.S. Supreme Court. I mean, things were done differently back then.
What year is this?
I think the Nagel decision was 1890.
Wow.
The individual, David Terry, who was the former Supreme Court justice, I think only served like a year on the California Supreme Court in like around the Civil War period or just after. So maybe they thought he was kooky and they got rid of him. I actually have never researched the backstory of David Terry.
So this is like as if someone in Minnesota on our Supreme Court, state Supreme Court, went and tried to assassinate Donald Trump.
Or Brett Kavanaugh.
Or Brett Kavanaugh. That's right. Yeah.
I mean, fortunately, President Trump has plenty of security already, I think by statute with the Secret Service.
But the Supreme Court justices probably don't even.
Well, they do a little bit, but this is interesting because Congress passed a statute after that individual was caught near Brett Kavanaugh's home, or in the curtilage of Brett Kavanaugh's home, which is the legal term for. Anyway, we'll talk about curtilage eventually. And so they passed a law providing for additional security. But if they had been alerted to a threat, could they have sent marshals to protect Justice Kavanaugh without statutory authority? And that's what happened in this In re Nagel case in 1890. So basically, the story is totally wild and nuts and insane. So back in the day, Supreme Court justices rode circuit, which meant that, today we have district courts, we have circuit courts of appeal, and then we have the Supreme Court. Well, back then, the Supreme Court justices were part of the circuit courts. So they had to ride circuit, literally on horseback at the beginning, eventually trains, and they would have to sit as circuit judges. So Justice Field's circuit was California, included California. And so as a circuit judge, he ruled in a case involving the former California Supreme Court Justice, David Terry.
Okay.
David and his wife, Sarah, tried to fake a marriage certificate to a wealthy decedent, someone who had just died because they wanted his money, to inherit his money. Yeah,
Wow.
and Justice Field...
I know someone in Congress right now who
Someone's doing that?
may have faked a marriage certificate, but we can keep going.
Oh my, okay. All right, all right.
Save that for another day.
We'll save that for another day. I will say my name is Ilan, not Ilhan, right? Sometimes people say
get a little
Elon.
H in there.
And I'm
Ilhan.
like, are they talking about me? That's a little bit of different pronunciation. But anyway, so fake marriage certificate, very, very well done. Ruled against them, said this is a forgery. And in open court, David and Sarah Terry basically tried to strike the judge. They created a scene in open court. They were held in contempt of court. They were in prison. And they, from then on, threatened the life of Justice Field from then on. And so what happened? Well, the Attorney General of the United States sent another David Nagel, who was a deputy U.S. Marshal, to protect Stephen Field while Stephen Field was riding circuit in California. The problem is there was no statutory authority to do this. And so here's where things get crazy.
This should be a movie. Go
Someone
on.
should make a movie out of this, actually.
Great content.
So here's where things get totally wild. So Field was on a train, I believe, from LA to San Francisco, maybe San Francisco to LA, when David Terry entered the train and entered the dining car where he was. And he, it was something like, you can read it in the case, but either put his hand in or he actually struck Field. And David Nagel, the marshal, told him to stop and shot and killed him. Now, it turned out...
Wait, he shot and killed them both?
No. He shot and killed David Terry, the former California Supreme... So in defense of Justice Field's life. So what happens? He doesn't actually have a gun on him, although he did strike Justice Field. So David's wife, now widow, Sarah Terry, has the local marshal, Marshal Cunningham, arrest the deputy U.S. Marshal.
Oh my gosh.
On charges of murder. And so then David Nagel, the marshal, is sitting in a California prison and sues for a writ of habeas corpus under a statute that authorizes his release from state custody if he was arrested for doing something in pursuance of the laws of the United States.
Wow.
Well, there's the problem.
Yeah.
There was no law
Right.
authorizing the Attorney General to assign David Nagel to protect Justice Field. Now this went up all the way to the Supreme Court. Fortunately, Justice Field recused from the case, which you never know. People talk about the recusal rules, and should Justice Alito recuse because he has oil stock, which he does recuse because he does have oil stock, which is like, dude, sell your stock. But okay, whatever. Anyway, Field recused. And so I guess in like a 5-2 decision or something like that, the court held that although no specific law of the United States authorized the marshal to protect Justice Field's life, that this authority to send him just emanates from the entire executive power. The right to see that the laws be executed in every inch of the union implied this power to protect the instrumentalities of the federal government. So look, could President Trump invoke this protective power and send in the militia or the army solely to defend the life of ICE agents?
Right.
So look, how much of a difference does this make? Is it practicable? There's that word again.
Is it practicable?
I don't think they could do domestic law enforcement, but they could maybe accompany ICE officials, and they could probably disperse crowds to ensure their protection. I don't think they'd be able to arrest necessarily anybody because, again, the protective power seems to be limited to physically protecting the instrumentalities. But he probably could do this, though there are tons of open questions, and maybe it would be just sort of a slightly less radical step than the Insurrection Act. But look, I generally, in my book, you'll see I'm actually a skeptic of the Nagel case. I'm a skeptic of inherent executive power. At the end of the day, the president... It
seems kind of like a slippery slope.
Yes, it is. And we'll talk about, I think, Venezuela and inherent power, military power in a couple episodes. At least we're planning to do it. But it just seems to me that the president can't execute the laws. There's nothing to execute until Congress passes a statute, and the president can only execute the laws with whatever officers and employees that that Congress establishes, right? Congress establishes offices, Congress appropriates for offices, Congress establishes duties. And so anyway, I'm generally a skeptic but of inherent executive power. But the point here is everyone, liberals, progressives, who writes about this topic tend to believe that this power exists. And so if that's true, then like it seems to me it is at least potentially could be deployed in this case.
Does it get invoked very often?
I am actually not aware after the well, there were some situations that it plausibly was invoked, but there were other statutory authorities. So, so there's a case called In re Debs, Eugene Debs, after the socialist presidential candidate. There was a crazy strikes throughout the nation, including in Chicago, over the Pullman car companies. And so the federal government argued, well, we have contracts to carry federal mail over the railroads, right?
So interesting.
And they said, well, look, so they got an injunction under the Sherman Antitrust Act, but it really didn't apply. Anyway, and the injunction said the strikers had to disperse. They refused to disperse. And so then Cleveland. I'm confusing my Gilded Age presidents.
Oh, no. I do that all the time.
Yeah. Gilded Age, great show, by the way. Have you ever seen Gilded Age?
I've never.
It's like Downton Abbey, but
I've
like
heard
1880s
that,
in
and
America.
I love Downton Abbey.
Oh, wait, what's it on?
It's awesome. I wish I knew. Maybe
Like
HBO,
HBO.
Netflix,
That sounds
something.
sweet.
I'll source that.
I also watch it. So anyway, a Gilded Age president, Grover Cleveland, then sent the army to disperse. And so arguably this was somewhat protective power. The court arguably based it on this a little bit. But that is kind of interesting, that a court did get involved there and issued that injunction that was then ignored, that kind of gave the excuse to go in. So very interesting stuff.
I'm glad I asked that because one of the things that surprised me when we first started talking about the Insurrection Act that started being thrown around was how many presidents had invoked it. I think it was like 16 presidents or something had invoked it at one time or another. That's a crazy percentage. That's like almost that's a third of the presidents. So that it was to contextualize how often something is used, I think is helpful.
Yeah.
Including to enforce desegregation orders.
Yeah.
Right?
Yeah.
In the 101st Airborne. That's right.
So if Trump did invoke the Insurrection Act, just a what if, would the courts have had anything to say in the matter? Or are these two completely separate powers and they couldn't have done anything about it?
Yeah, so this is interesting because there was the National Guard cases where he tried to deploy the National Guard to Oregon and Illinois and LA, and the courts did step in there. If the Insurrection Act was invoked here, would the courts be able to step in? And what about the Minnesota lawsuit? Like they're trying to get the courts involved, right? Just for deployment of ICE officers.
There's
they're already trying to get
one
involved.
judge who gets to decide, it seems like, if who wins, the state suing the feds, and this one random judge just gets to decide. It seems crazy to me that they have that much power.
So historically, they did not have that kind of power. Right? I mean, the question here is really, what is judicial power? And judicial power is the power to adjudicate disputes. Usually a private party has to be injured. Okay, so to adjudicate a dispute when there's a private injury under existing law. So so the government often does unconstitutional things. It doesn't mean you can sue because you haven't been injured. So if nobody is injured, you can't invoke the power of the courts. But if there is an injury, then you can invoke the power of the courts, who will necessarily, as part of this judicial duty, decide whether the law has been violated. So there's this. So in the War of 1812. This actually became an issue because James Madison called forth the militia to help repel the British invasion. And somebody thought that this was unconstitutional because there actually wasn't a legitimate threat in New England of invasion at the time. And so this guy, Jacob Mott, refused the call. He refused the call. What happened? He didn't just go to court and file a lawsuit and say, I think this is unconstitutional. Courts, you play commander in chief. No, that's not how they did things. So what happened? It's totally wild and crazy. So he refused the call. He was court-martialed in absentia. He was fined.
What is absentia?
In absentia, he wasn't there. He didn't show up to the proceedings.
Okay.
Right? So he was court-martialed.
We need a bell every time I hear a word that I've never heard before.
I just ran past habeas corpus. I was like, I don't know, whatever.
This is why the body of this is why I have you because I want to make sure that non-lawyers also understand all of this stuff because it's super interesting. But so he was tried in absentia because he didn't show up to the proceedings, and he was convicted and he was fined. He refused to pay the fine, and so what happened? The local marshal, who was Martin, I believe, seized his horse. He seized his horse to pay the fine, to pay the debt.
Gosh,
right?
Okay.
And so then what happened is that Jacob Mott, who again refused the call, sued the sheriff for unlawful conversion of his property.
Okay.
Right? And then you have a dispute. This is a legal dispute, a private tort injury. And the sheriff defended the seizure of the horse on the ground that the court-martial was legitimate.
And the tort injury is the horse is taken, because tort is what's the harm.
Yeah, exactly. You took someone's property.
He took his horse.
That's a private injury.
Yeah.
And it's exactly right. So that's a tort. It's a property injury, right? It's or tort or property. In this case, we call it conversion of property, which is a tort, right?
Yeah.
If you harm someone's property, it's a tort, a nuisance kind of debate whether exactly that's a tort, but basically it is a private injury to your life, liberty, or property, your private rights. And here, that's my horse. That's my property. You've seized it. This is a private injury. And so he sued the sheriff. And the sheriff defended on the ground that his actions were lawful because the court-martial was lawful, and the court-martial was lawful because Madison's call was constitutional. And thus you have a private dispute in which the courts necessarily must decide upon the validity of the call for the militia. Now, in that case, the court said, we give wide deference to the executive to decide. I don't know if we would give that kind of deference today, but the point is that's how the courts used to get involved in things. You couldn't just run to court every time you thought the executive branch was doing something unconstitutional. You had to wait until there was an injury.
Well, it's like that too in if you have two individuals where, I think this is a hard concept for people sometimes. You can't bring a lawsuit because something is simply wrong. Like, you feel like, oh, this is just unfair. I think people think of the justice system as being like the arbiter of all kind of unfairness, but that's actually really not how it works. You have to be harmed in some sort of tangible way, not just like, well, it's obviously unjust. There really has to be a harm,
there used to be a saying, which is like, not every schoolyard dispute is a federal lawsuit, which kind of just rings differently today, because I feel like every single schoolyard dispute is now a federal lawsuit, like harassment, sports, whatever, titles, anyway, but that's exactly right. Look, there are 600 plus federal district judges around the country. Just going back to the Oregon cases or the Illinois case. So the president, so the president says, I believe that the laws cannot be practically enforced through the ordinary course of judicial proceedings. Someone runs to court, okay? And the judge says, well, I disagree. Okay, well, who gives one of 600 federal judges the right to execute the laws in this way, to decide better than the president? Like, I have better judgment than the president whether the laws are being faithfully executed.
No one elected the judge, let me just add. We actually elected the president. No one elects the judge.
And the president has a duty of faithful execution. It's the president's duty to take care that the laws be faithfully executed. Right. And so judges can't just second guess the president, as I do think the judge in Oregon did, by the way. The district judge in Oregon did. And you can't do that. You have to wait till there's an injury. So if a guardsman or an ICE officer commits an injury, trespasses on somebody's property, injured, there's the shooting deaths that we saw. Those are injuries. And then if you have a tort claim or some other private injury, you could bring the case. And then the judges would necessarily have to decide for purposes of that case whether it was unlawful. Right? But even if a judge in that case decided, okay, the Insurrection Act was unlawfully invoked, well, the president could still continue to invoke it. It's just in this private case, the private individual would get a remedy, right? Would get money damages, would be made whole in some way. In a wrongful death suit, the families would get. But the president could still be commander in chief and could still, disagree with the court's reasoning, continue to use the militia or the armed forces. But when there's a private injury, the courts can and should decide for themselves, for purposes of that case, of remedying those individuals with private injuries. So that's historically how court proceedings, the court's role worked.
Okay, so then to that point, we've got this judge in Minnesota right now who's this magistrate, right? I think that's the word, who's refusing to sign these warrants for arrest that were sent down from the top. Warrants for arrest for some of these protesters who have been disrupting ICE's work in Minneapolis. And he's just refusing to sign them. And it sounds like there's this really interesting power struggle going on now between him and the people at the top at the federal government. So how is he allowed? I mean, walk us through that. How is that allowable?
Say first what a magistrate is, because I had never heard the word magistrate until this all came about.
So magistrate judges are only kind of real judges. They're actually assistants to the federal district court judges. So a magistrate judge, they don't have lifetime tenure and salary protection. They are assistants to the district court judges. And so they can only hear certain things like pretrial procedural things. They can hear certain petty offenses and misdemeanors with the consent of the parties. And so you often go to magistrate judge for these sort of administrative issues of like an initial arrest warrant or a probable cause warrant to search and seizure. Now, look, this is an interesting question. I don't know if this is judicial nullification, but if it is judicial nullification, then, that might suggest that the laws are not being executed decided by the ordinary course of judicial proceedings. And what's interesting now, I think we're going to talk about this a bit later, but the judge the theory seems to be that Don Lemon, who wasn't the arrest warrant for him and a few others wasn't signed, was participating as a journalist. So I think we're going to talk about that because Don Lemon has very interesting views on the First Amendment that we are
put a pin
excited.
in that.
He's certainly not a lawyer.
Excited to talk about. But something that's super interesting, this went up to the Eighth Circuit in an emergency posture, and the district judge, who was asked to review the magistrate judge, said, "Look, you could bring this to a grand jury." But we all know that what grand jury in Minnesota is going to indict, these folks, right? I mean, there might be, there are sensible people in this great state, okay? And again, maybe maybe he was really there just as a journalist, but there is some concern going on around the country about jury nullification and judicial nullification, which may make the laws impracticable to be enforced. I don't know that we're there, and I don't think a single magistrate judge, not issuing an arrest warrant. Though the New York Times did say that last night, I think that the Department of Justice has dropped it. Did you? I just read that this morning. I read that this morning. So I was
Okay. Well, there was an interesting thing, a discussion going on because I think that the one of the federal judges had declined to override it because he didn't think he had the authority. It felt like this whole administrative problem. So what, is Don Lemon not going to be in handcuffs like he deserves because of an admin situation?
Right, that's what I kept hearing. At this point, it's procedural. People outside the situation say, yes, there is reasonable cause to issue these warrants. But it's just a question of how we can basically force the magistrate to do it.
And the magistrate had just come out. Of course, his wife is working in the office of Attorney General Keith Ellison. So is that jury nullification?
It's not a good look. Should the magistrate judge have recused? Maybe. But they do have other options, and the district judge does have authority over the magistrate judge, right? And the district judge can decide these things. De novo, can reverse a magistrate judge, can take matters from the magistrate judge, and the district judge certainly didn't have that connection. So why he thought he didn't have the authority was super interesting. I think he does, and I don't know if that's. But I guess we're not going to find out anymore what's going to happen if it's true that the department has dropped it.
But I would be sadly very disappointed. But I think we should move on to another issue that's similar, but that everyone's really talking about. It's the issue of these administrative warrants, because this is also a role of the courts kind of thing. A lot of people are saying that when ICE goes in to basically do a seizure of these people, they do not have the proper warrant because they have an order for deportation, but they only have an administrative warrant is what they keep calling it, right? And so the question is that enough? Is ICE doing this legally, or is this actually illegal because they don't have the proper paperwork? Well, what say you?
Well, I'm glad you asked, because we talked a little bit about this before the show, that I've been getting a lot of heat from my fellow academics. I say fellow, although most of them are on Blue Sky. And so I am not on Blue Sky. I think for good reason, but I do consider some of them friends, and I do take their criticisms seriously, though I do think they were a bit unfair. I think you are all wrong about this. Okay, and now thank you for the opportunity to explain
absolutely.
why. So I think the place to start is under the Fourth Amendment. The general rule is for criminal proceedings. For criminal proceedings, before you can enter someone's home to search for criminal evidence, you need a warrant. And a warrantless search is presumptively unreasonable under the Fourth Amendment. And then there's exceptions like exigent circumstances, if you're worried about destruction of evidence or somebody's fleeing or someone's in danger. I mean, there are all sorts of exceptions to this general proposition that warrants are required. Okay, but this warrant requirement for entry into a home, judicial warrant, emerged from a little bit before, of course, but like the key case, Payton, came against New York, was in 1980. It involved a criminal case in which there was no warrant whatsoever. These cases, at least here, when they have a removal order, in order to be removed from the country, you can be arrested and removed from the country. These aren't criminal cases, right? They are not even really civil cases. They're administrative deportation proceedings. And so here we don't have criminal consequences in most cases, right? Maybe they find criminal evidence when they're there, and that's sort of a separate question, right? But these are not criminal cases. They're administrative deportation cases. That's the consequence. It's an administrative consequence, not a criminal consequence.
But
and there's an administrative warrant. There's an administrative warrant. right? The executive branch said you are removable. I don't think this fits in the rule, the default rule that in criminal cases. Okay, now we in fact have a case about this from, was it 1960? I think we talked about this.
1960, Abel versus U.S. Okay,
I think I pulled some quotes about this because they're pretty amazing quotes.
Wait, can you just clarify 1 second? You're saying that it's not a crime to be an illegal alien. I know there is some separation. Can you just explain that?
Yes.
Because to me, it's like, it's obviously a crime.
Thank you. It is a crime, and the statutes provide, for example, if you illegally re-enter after being removed, right, or if you're that you could suffer criminal consequences. But so if the consequences are criminal and you're purporting to pursue criminal charges, then you may actually need a judicial warrant. But if you just have a removal order and that says X, Y, or Z person who lives in A, B, and C address should be removed, that is the deportation is not a criminal consequence. It is an administrative proceeding. And it's administrative actually because immigration is what's called a public right. It's a privilege, right? Just like you can adjudicate Social Security benefits in an administrative proceeding because it's not a private right. It's a privilege. It's a public privilege that the government can choose to give or not. So these are administrative proceedings, which isn't irrelevant here. Because it's a public privilege, as a condition of granting that privilege, Congress can condition entry into this country on all sorts of things, including foregoing rights you otherwise might enjoy, like Fourth Amendment rights. This is called the unconstitutional conditions doctrine, which I've written about. It just has to be sort of like germane to the purpose of the program. And so you can say, look, you come into this country, but if we find you deportable, we have a right with an administrative warrant to come get you, like kind of wherever you are. And so the question is that what the statute provides? Does it provide that condition? Yeah. And I think it does. I don't think the judicial warrant requirement makes sense for the following reason. The INA, the Immigration and Nationality Act, specifically provides that final orders of removal are not reviewable by district court judges.
Okay.
They're only reviewable by circuit courts of appeal, and it's a limited scope of review. So suppose you go to a federal judge to get a warrant to enter the person's home. What's the federal judge going to do? So either it's going to be a rubber stamp. Okay, you have an administrative warrant saying this person who lives at this address is removable. Okay, rubber stamp. Well, that doesn't do anything. It's not a protection in any way. It's a rubber stamp. Or if the judge says, well, actually, I want to look to see if this person is actually removable. You can't do that. The statute doesn't allow you to do that. So you want to make sure, I want to make sure you're going to the correct address. Well, the judge doesn't have any independent information. The judge just has whatever information that the government gives them. So there would be 0 point. It would be a violation of the INA, of Congress's statute, for a district judge to look behind the curtain of the removal order and intervene here. So what is the point of requiring a warrant in this case, right? And so under the Fourth Amendment, is it an unreasonable search? Or to say, we have an administrative warrant, the statute doesn't allow review by district judges, is that a reasonable search? And we have the Abel case that seems to support it. Okay, I know I wanted to print this out so we could read it.
I think I've got it. Statutes authorizing administrative arrest to achieve detention.
Yeah, this is a Frankfurter. Felix Frankfurter, New Deal Democrat, for the majority of the court in Abel. This wasn't the holding of the court. It wasn't necessary for the decision, so we call it dicta, so it's not binding. But the fact that he went into such detail about this suggests that, this is what they thought about this. Okay, so you've got it in front of you. Why don't you start reading it?
Yeah. Okay, so statutes authorizing administrative arrest to achieve detention pending deportation proceedings have the sanction of time. It would emphasize the disregard for the presumptive respect the court owes to the validity of acts of Congress, especially when confirmed by uncontested historical legitimacy, to bring into question for the first time such a long-sanctioned practice of government at the behest of a party who not only did not challenge the exercise of authority below, but expressly acknowledged its validity.
And so that's why that's dicta, because it wasn't actually challenged. But then he goes on to say this, like, look, this has the sanction of time. This is confirmed by uncontested historical legitimacy. Oh, there's more. So it says, statutes providing for deportation have ordinarily authorized the arrest of deportable aliens by order of an executive official. Back to 1798, he goes through all these statutes. To be sure, some of these statutes dealt only with aliens who had landed illegally, not aliens who sought to be deported internally from the country. Even apart from these, there remains overwhelming historical legislative recognition of the propriety of administrative arrest for deportable aliens. And this case, by the way, involved, he was arrested in his abode, in his home. It was a hotel room at the time, but because he was actually a spy, he was a Russian spy. So it's just like a whole separate question. But again, like, go back to the New York v. Payton case. Or the Payton v. New York case, right? They say in that case, which again, it was a criminal proceeding, no warrant. He says that there was the court in Payton said there has been no congressional determination that warrantless entries into the home are reasonable. It's like, well, here there has been 200 years of congressional determination,
right?
And arguably the INA is one of those determinations because it doesn't allow review of these removal orders. So at least when the administrative arrest warrant comes with a removal order, and that is the purpose of the administrative warrant, I don't see how Payton and all of those other cases apply.
Yeah, it's interesting. I think a lot of people claim that they're not getting their due process, or they're using that word. But to get to the point of having that removal order, they've already gone through a whole court process, right? So that is their due process. There's not the need for an additional rubber stamp or whatever, like you said.
Yeah. Well, this is a much longer conversation that maybe we should also talk about. I think we were going to talk about birthright citizenship at some point, maybe our next episode. But historically, it seems, based on my historical research, and Philip Hamburger has a little bit coming on this too, that aliens who were in the country unlawfully actually had no due process rights, which is interesting. Like the 14th Amendment does say that no state shall deny any person within its jurisdiction equal protection. So there is some constitutional text that seems to be in tension with this, but the idea was your only right was a habeas corpus proceeding, which again, you're imprisoned, but and what is the validity of your detention? And the court would be able to say, okay, are you illegally here? That's it.
Right.
Then there's no other process that you're sort of entitled to. So they have, but even so, they do have quite a lot of procedural due process within the executive branch. That's absolutely true.
Okay, I think we've got time to quickly run through the final topic that we want to talk about, which is the infamous storming of Citizens Church in St. Paul and whether that violates the First Amendment. And we can also hit on some of the insane protesters that seems like may not face any consequences for what they did. But okay, first, let's just roll the clip. This was taken inside a St. Paul church about a week ago. So protesters walking down the aisles of a church in progress, packed pews,
Do we
kids,
know
families.
if this video comes from Don Lemon? Is he the one holding the phone?
No,
He's not the one holding the phone right now, but he has similar videos like this.
They're walking up to the altar.
Look at all these people. I mean, they only have charged 3 people.
It's a big crowd in there, yeah. Families and kids. We know now they were preventing families from getting down to Sunday school to pick up their kids and get out. One woman broke her arm trying to get out of there. They were accosting people in the streets. People were crying. Very traumatic event, I would say.
So what crime have they committed? I'll ask you. What is the FACE Act?
The FACE Act! Okay, I forget what it stands for, but...
I think it's federal... Okay, hold on. We wrote this down because they always come up with these clever names. It's a Federal Access to Clinic Entrances Act, because it was enacted in the 90s
Under
to protect
Clinton.
people going into abortion clinics from being intimidated and harassed. But then there's this other paragraph about and religious assemblies. You can't interfere and intimidate religious assemblies. So was that like a compromise? Was that like the Republicans saying, okay, well, let's add this? I don't know.
Saw a lot of talk about, when I looked into this, that conservatives saying we need to get rid of this because this law is just used against us. In theory, you could use it against Democrats or liberals who were out front of a women's health center or something like that. I think originally was the idea that it was kind of bipartisan, but historically it's only been used against, people who were standing outside places like Planned Parenthood or places that performed abortions.
Didn't
famously,
the Biden administration do a bunch of stuff
the
here?
Biden administration, I think, charged over 20 people who were supposedly blocking the entrance to places like Planned Parenthood, including one 89-year-old Soviet camp survivor who was praying out front of one of these places.
Just like quietly praying?
They're just quietly praying, but supposedly blocking the way for people to get in there. So that's the idea, is that people could not reach.
So if you're quietly praying but obstructing, if that's a FACE Act violation, everybody there needs to be arrested.
Absolutely, yeah.
Right? So that seems pretty clear. So Don Lemon wasn't arrested because I think the theory being
maybe
that he was engaged
as a journalist?
protests.
But who cares? There's a bunch of other protesters. I mean, there were like at least 5 we know, 5 charges that they were trying to file against these protesters. He's the only journalist on that list. So I think that's BS.
We put journalist in the little air quotes because, he's got like a YouTube show now.
Yeah.
Well, okay. So
I'm a journalist,
it was
I guess.
clearly like agitating.
We're nearing our hour. So let's just say, look, I don't know whether Don Lemon was there as a journalist. I don't know whether he violated the FACE Act, which is, pretty broad. Any attempt to interfere or intimidate, with an act of religious worship. But he does have a running commentary about the First Amendment, which we just had to end on because I think it is absolutely spectacular and hilarious. Roll the tape.
This is the beginning of what's going to happen here. When you violate people's due process, when you pull people off the street and you start dragging them and hurting them and not abiding by the Constitution, when you start doing all of that, people get upset and angry. And if you remember what the Civil Rights Movement was about, the Civil Rights Movement was about these very kinds of protests. There's nothing in the Constitution that tells you what time you can protest.
Okay, all right, stop. All right,
Okay, not true.
Stop the tape. Okay, Don, it's called literally the time, place, and manner doctrine. Time, place, and manner restrictions are allowed. Here is Ward v. Rock Against Racism from 1989. Our cases made clear that even in a public forum, let alone a private church, while other people are exercising their rights, even in a public forum, the government may impose reasonable restrictions on the time, place, or manner of protected speech. So there actually is a time limitation. Okay, 0 for 1. Let's continue the tape.
You can protest at any time. That's the whole point of it, is to disrupt. It's to make uncomfortable.
Okay. All right. 0 for 2, Don, because actually it does say something about disrupting and making people uncomfortable. It literally says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for redress of grievances. It literally says your assembly has to be peaceable, and storming a church and interrupting people exercising their religious First Amendment rights is not a peaceable assembly, arguably a violation of the FACE Act. So I hope you really were just there as a journalist. So maybe you won't get charged, but you should definitely stop playing a lawyer on TV.
Word.
Yeah, amen.
Well, that's it. What do we have? Oh, and of course, don't forget, we probably should say this at the beginning. I'm sure we can add in the beginning after the fact. Don't forget to like and subscribe and to follow us on all the channels on which you see this. We're going to try to produce episodes once a week. But what do we have coming up for our next episode?
Well, first of all, you should give us some feedback too. I'd like to hear what you guys want to hear about on our next episodes. But I think what we should do next is probably talk about birthright citizenship, because we actually have the expert with us on birthright citizenship. I know you were supposed to, I think this week, testify in front of Congress, even, Ilan, that did get postponed, right?
Yeah, it got postponed because apparently if you don't live in Minnesota, like 15 degrees is cold.
Oh my gosh,
or
that's
like
so
2
funny.
feet of snow is like a problem. Which actually 2 feet is kind of a lot, isn't it? I'm trying to use my...
2 feet's kind of a lot.
It is kind of a lot, but I don't think they ended up getting 2 feet. Anyway, yeah, it was canceled. But I should be, I hope, testifying about this issue. And I've written a long article about it. And long story short, the Trump administration is on much firmer footing here than is traditionally believed. And, hopefully we'll have a chance to talk about it since it's pending in the Supreme Court right now. So maybe that'll be our next episode.
Yeah, this idea that if you are born on the land that is the USA, you are automatically a citizen is actually kind of up for debate. So I love that topic. I didn't know anything about it until I met you and read what you have written about, Ilan. So I would love to do that next. But everyone, let us know. Drop a comment. Send us an email. What do you want to hear us talk about? And please share this with a friend if you enjoyed it. We're obviously just getting off the ground here, but I think we have something good going. As long as I got a couple terms to learn, right? As I go along, habeas, whatever. But
we'll bring a legal dictionary
for
the next one. We got to talk about Venezuela at some point.
Yeah.
I almost feel like it's old news, but I've been listening to some other pods about this, and we'll call them friends of the show. I don't think they've quite penetrated the issue, and so it would be fun to talk about Venezuela at some point. But let us know. And thank you.
Hopefully you guys found this episode helpful. Obviously, these are complicated issues, but we're trying to break them down for you in a more easily understandable way. Stay tuned for Birthright Citizenship next week. Drop a like, drop a comment, subscribe, turn on notifications, and we will see you next week.